somebody will take care of admitting. Okay.
Yes. I am take care of admission.
Yeah. Okay. And yes, one more thing. Because this is a deep dive set of programs, so questions are welcome throughout the session. Don't wait for the end because you might forget what you have thought of at that moment. Just use the raised hand symbol. I will recognize you and we will listen to it. But as far as possible, keep the question to the topic that is actually being discussed at that time. Anything else, obviously, we will have at the end. You can always, last 10, 15 minutes of the program, on every session, we will keep for those questions which have arisen subsequently. Okay? Yeah, this act is as much new for me as for everybody else. So when I say this is my opinion, it is just prima facie opinion. There's nothing hard and fast about it. People can have different opinions. And from our discussion, we will try to come to what could be the most likely meaning of any provision. Okay. I am going to cover only those aspects which I think are material. For example, I will not dwell at all on the 14-day time limit given to adjudicating authority. It's meaningless for us to debate about it. NCLT and the Parliament will deal with each other about that, what is right or wrong. We have no influence on it and no connection with it. So we will not get into that. It's there, it's there. Okay. So we will look at how, especially those provisions which have an impact on what we do. So the first thing, like from the definitions, security interest. Okay, this has created a lot of problems in the first 7, 8, 9 years of the IBC. There was an understanding at some point that security interest means as understood over a period of time, and which usually meant that broadly there are three types of security interest. That there is the first charge, second charge, that type of thing. And then there is the pari passu charge. And thirdly, security interest created by operation of law. Our general understanding was prior to IBC that all of these have sort of equal footing. Obviously, first charge ranks higher than second. Yeah. But somewhere along the line, and in the first couple of years, suddenly some judgment came which said, no, IBC does not specifically talk of charges. It's talking under Section 53. They just word secured creditors. Okay. There's no distinguishing. Shrikant Jawar, please mute your mic. Yeah. So, yeah, Harish, keep track of that. If somebody's background noise is coming, please mute.
Yes, sir. Yes, sir.
Yeah. So, what was the confusion was, okay, whatever was the business practice for decades, maybe even centuries, if you look across jurisdictions, suddenly overnight vanished. And they said, okay, security interest is same, secured creditors all same. I mean, to put it in a light manner, gada goda sab equal. Okay. The issue was taken up by the ILC in its report. I think it was the first report itself, when it clearly said that this issue has been settled during the Companies Act days, Companies Act 1956, in the judgment of the Supreme Court, ICICI versus Sitco Leather, Sitco with the SIDCO, that the priority of security interest will stand because anything which is an arrangement. Now, where does this priority of security interest or the concept of charges come from? There is no law, at least to the best of my knowledge, which says or uses the word first charge, second charge, etc. It doesn't exist. Okay. There is Section 48 of the Transfer of Property Act, which basically says that a charge created prior in time will be superior to that which is, or in priority to that which comes later, subject to any agreement between the parties concerned. What does it mean? This is where the concept of pari passu came in, that if there is a creditor A who has given the first loan, so he gets a charge. He is the only charge, so automatically in what we call first charge. Then the borrower needs more funds, so another lender comes in, lender B. But that lender says, I have to get charged at parity with the other. So the borrower now has to go to the lender A and say, are you willing to cede pari passu charge? Usually they do if the value of the security interest is adequate. And then you get a second person coming later in time, but having the same right as the first one. So this is the Section 48 of Transfer of Property Act, which distinguishes between prior in time and pari passu. Now the concept of a second charge is by custom and usage. It is not there in any law. So how does it have force? So to that, we have to go to the Constitution of India, which defines law, which includes custom and usage, which has acquired the force of law because of use in a prolonged period of time. Okay, so coming back to that, that was the background of what is a security interest. So during this IBC, this problem happened. The well-established principle of ranking and priority of charges as pari passu, first charge, second charge, subservient charge, etc., got demolished effectively. And for some time, at least, everything was like, oh God, I mean, everybody is sane. It is our good fortune because of the peculiar system we have in India that the second charge holders are also usually the first charge holders. So it did not matter much. Otherwise, it would have destroyed the economic landscape with that type of clarity. But still, there were problems. And the problems were more faced by the NBFCs who were not, who had largely acquired or lent for loans for fixed asset generation and not for working capital. And they started getting the pinch of it. So finally, I think the parliament and government listened and they decided that no, that security interest, priority, etc., has to be made. Now you will realize that I have gone beyond this definition, but it's easier to understand when the same topic is understood, because here is about what is a security interest for the purpose of IBC. And I was right now talking about other things like Section 53 ranking of charges. So coming back to the specific definition here. Now, the words which are used here in the beginning, they are critical for the removal of doubts. It is hereby clarified. Now, whenever any law has these words in any provision, now that provision one is supposed to be clarificatory only, which means it was always there, but people like us, we didn't understand it. So the parliament is clarifying, okay, this is what we meant. Second, it is always with retrospective effect, but with one caveat that usually, okay, acts which have attained finality based on the old interpretation will not be reopened. But those which have not, like for example, ongoing processes, then it will affect. So if there is a CRP going on where a security interest created by operation of law was taken into account, but it has not attained finality in the sense it has not yet reached the resolution plan stage, then this definition will apply. Okay. Now, security interest created by operation of law, okay, the words itself are very clear that some act, some rule, somewhere, statutory, either at the central level or state level, it doesn't matter, has to have wordings which say that such and such a due, which need not be a debt, but it could be a due of taxes, duties, etc., if remaining unpaid, will have a charge on the assets of the person who is liable to pay the dues. It has to be written in that law. And only on that basis, if the charge is claimed, because it doesn't actually, it gets created by operation of law, there is no documentation, there is no filing with ROC, etc. in general, with one caveat again, which is in surfacing. Okay. So you may not find evidence of it elsewhere, but the law itself says that it is instantly, the moment there is a default in that particular dues, then a charge has got created. So that is created by operation of law. Now here we might think of certain things like, for example, landowning agencies. Okay, the famous case of Noida Authority, GNIDA, MIDC, etc. Some of them, in some cases, there is a law which also creates a charge. Now in Uttar Pradesh, it is there. And that was the basis of the, I think the Prabhjit Soni judgment, that the law, the UP Act, it was a state act which created it. So Supreme Court recognized that these dues are secured. Okay. They were, of course, said operational credit, but still secure. Now, there will be some cases, now this is where we as RPs have to be very careful, that the agreement between the land agency and the corporate debtor, whether for the purchase or lease of that land, if that also includes a clause which creates charge, whether there is such a clause in an act or not, then this definition will have to be looked at carefully. Then it is no longer merely by operation of law. And that's where these words come. Shall not include a security interest created merely by operation of law. So if this security interest, there is a law which creates it, but it is also included in an agreement between the parties, that is the corporate debtor and that particular creditor, then it shall not be treated like this. That means it will be treated like any other security interest. Okay, any questions still? Because of all the things that we'll go through, probably the most significant amendment is this one.
Sir, Uttar Pradesh judgment you referred to, which was the case?
Prabhjit Singh Soni, I think. Noida Authority or Greater Noida Authority, I think. One of the two. Prabhjit Soni karke, it's famous like that. This is where the Supreme Court basically said that the law has created a security interest, so this party is a secured creditor.
Raviji,
Provident fund comes under law created security.
Sorry, can you be louder? One second. Hemant Mehta ji. Boliye. Hemant bhai.
sir, I have a case where, there has been a decree which has been granted, and then because of the decree, there has been a mutual consent agreement where the unpaid land vendor has been given a charge that in case if it is not paid, then this will be subject to that charge.
If the agreement says so,
or not agreement
doesn't say, but
it is subsequent
to which creates the unpaid vendor lien. That's different.
Yeah.
If the agreement says so explicitly that I don't pay you in time, then that I owe you will be a charge on this asset. That is covered here. That is a security interest. But if the reliance is placed on Transfer of Property Act or a Sale of Goods Act, if it is movables, where the unpaid seller's lien or buyer's lien is there, so that will not be covered because that is excluded.
Here there is no mention in the agreement. It is mentioned in the decree and consent term basically.
So that's an agreement.
Decree, subsequent to decree.
Consent terms is an agreement because it's signed now by both parties. If this consent terms or any agreement by any name, if they mention that a charge will be created, then it is there, irrespective of the fact that the corporate debtor failed to carry out the procedure. Okay, there will always be a challenge. There will be a claim of laches. Why did the seller keep quiet for years or whatever? But that's a separate thing. If you are asking the question in terms of pure law, wherever there is an agreement which says that a due will have a charge, then that is covered under the definition of security interest under IBC.
So here there will be a case of operational creditors who is a secured.
See, the secured creditor, and see, first of all, please realize, all of you, the words operational creditor, financial creditor, other creditor are an IBC creation. They don't exist in general law. There's nothing called an operational creditor and a financial creditor. There is a creditor. And there is either secured or unsecured. That's it. For centuries all across the world, this has been the only definition, that either you are a secured creditor or you are an unsecured creditor. Nothing more, nothing less. It could be money that you are given, it could be goods and services. Nothing places one higher than the other. Secured creditors are always treated higher because that is the meaning of security interest. Okay. Now, that's why in IBC you say, oh, OC could be secured hoga. Of course, what's wrong? Security interest and status under IBC for a limited purpose of insolvency resolution are two different things. IBC is not a security interest creating law. IBC does not create a charge. IBC only takes cognizance of what has already happened.
So in that case, whether the secured operational creditors can say that I am also in line with the secured financial creditors and I should be given the same amount of treatment which has been given
Under
to say
53, there is no distinction between a secured FC and a secured OC. Okay? There is no distinction.
IBC plan.
For IBC, they are all same. And IBC is not new. I mean, open up the Presidency Towns Insolvency Act or Provincial Towns of 1920, 1908, that period. They also have the same thing. Hey, video बंद करो यार. Who is the holding the admin?
Sir, yes, unmuted.
Please do this quickly, yaar.
Sir, muted, sir.
Muted nahi, just video बंद करो. People don't realize their video is on. Okay. Sorry. Please, आप लोग take care of this, otherwise I will have to do it. So where were we? Yeah. You are okay. No difference between a operational creditor and a financial creditor in terms of ranking under Section 53. It does not recognize differences, but it does recognize unsecured financial creditor. It doesn't distinguish between secured FC and secured OC, but it does recognize unsecured financial creditor, which is different from Companies Act 2013 or Companies Act 1956. So please go and read back. The waterfall mechanism is at least more than 150 years old. It has not come with IBC. It just slightly changed under IBC. Nothing more. Okay. Ganesh.
Sir, good morning, sir. So I just wanted to know the decree holder. Now the definition, because in the definition they have given creditors different classes, secured creditor and decree holders. In the definition they segregated. And when someone gets a decree, okay, will there be the impact on the security interest, whether it is in agreement somewhere? That is one. Second thing is on home buyers.
No, one at a time. Otherwise, I will forget my chain. Okay?
Okay.
First, because they are totally different. What is a decree holder? A decree holder as a judicially adjudicated evidence of a debt and nothing more. A decree does not create a security interest. A decree creates an enforcement interest, right? Totally different. Okay. A security interest and an enforcement right are different. You might have a security interest, but not have an enforcement right for other reasons, like moratorium or something of that, or because you have agreed. But a decree is enforceable. What is a decree? Order of court, which is enforceable under law. It is just two things it creates. It finally adjudicates what is the amount payable between the two parties. So it's a judicially adjudicated debt. So no further evidence is to be sought by the IRP or RP. Once there is a decree, just admit the decree amount. Don't get into, you have no right to investigate the decree or go into backup any other document. Decree is fine. Okay. Only thing, make sure it is actually not a forged decree. That's all. Okay. So decree does not create security interest at all. Some judgments you might see which says, oh, decree holder. No, that is bad law. That is not the right way, this thing. Because they are totally two different things. When does a decree come? When the decree is a result of an adjudication of a dispute. When there is no dispute, there is no decree. Does it mean that fellow is lower in court? No. So arbitration award, decree, which are similar to each other, they are conclusive evidence of the debt or whatever is the payment. Nothing more. No security interest is created by itself. Unless a particular law allows you to do so. Okay.
See, the
It might
question,
be. Tomorrow we might have a law which says a decree can be, registered under SARFAESI with CERSA or something. That might create a security interest, but that's a subsequent. Yeah, second, home buyer.
the question came up primarily because there are judgments, and I do not know where, if you are a home buyer, for example, who gets a status of a secured financial creditor under Section 5(8), the moment some of them have gone to RERA or some other places and they got a decree. Now they are no longer considered in that creditors in class. They are put in decree.
That has been settled.
Yeah.
There is a Supreme Court judgment on that. That decree, I mean, anybody who has a RERA order and does not have a RERA order, there is no difference between the two.
And
There is a Supreme Court judgment, which there was sometimes you have this because of the words used in a particular judgment, how we understand it, how we filter it with our own bias. Because there are some people biased towards home buyers, and there are a few who are biased against it. So you will see the same thing in different light. But yeah, that has been clarified.
okay.
So anybody who gets again a RERA order is just a crystallization of a dispute.
Security interest, sir, on the home buyer security status. Now, the second part of the question. Whether
home buyers are secured or unsecured.
Because of the mortgage. There's a registered mortgage of the agreement for sale.
No. Agreement for sale. What is registered mortgage and agreement for sale?
No. Banker, I have a registered deed, and then bank had given a loan against that to the build. I mean, to me, which I've given to the builder.
No. Who are you? You are an allottee?
I'm a home buyer. Yeah, allottee.
Okay. You have an agreement for sale?
Yeah.
Which is registered?
Yes.
Then under Section 11, you get certain rights. It is not called as a security interest, but it is as good as or even better than a security interest. It creates a preferential right. If you go back to 1956 Companies Act, Companies Act had, of course, secured creditor, etc. But it also talked of something called overriding preferential payments. These are payments to be made irrespective of whether they have security interest or not. Like they have a saying in Hindi, "Sari dunya ek taraf, Jori ka bhai ek taraf." Like that. So preference can be created without it being a security interest. So home buyers under Section 11 of RERA are given a preferential status, basically because what does that entire section say? That once that agreement is registered, of course, which is the obligation of the developer, okay, then no further action of the developer will dilute these rights of these people. So, but any security interest created prior to that, like at the time of, say, project loan, real estate companies do take project loans prior to and to start the construction. At that time, they do create a security interest. Now, that security interest actually will remain, right? Now, the tussle here is that once homebuyers come in with their own rights, who is superior? So, one is the general law which says that the secured creditor is superior, but with the tilt of the Supreme Court to saying that allottees' right to housing is equal to right to life, Article 21 will override everything. Okay. So when the dispute will come, then the home buyer, irrespective of somebody else having a prior security interest, the courts will treat them to be at a higher rank, even though they do not have a security interest. But that is the deriving from defining the right to housing as a right to life.
Yeah, but that's an interpretation. From a definition from security interest perspective,
Okay, that's why I said no Supreme Court. Okay, what did I say?
Supreme Court.
One is law, other is what is the law? The law is what the judge says it is, ultimately. Okay?
Thank you, sir.
Okay, service provider, expanded definition, but we have to wait for this notification of the central government. Who all are included. We have been discussing in various sessions over the last 6-8 months, from the time the amendment bill came, that now it will include contract providers, etc., etc. We have to wait because certain definition notification has to come from the central government. But it is assumed that it will broadly cover people like auditors, etc., because they are an essential requirement of the information that an RP requires during. Some of these I will skip because we already know that. Okay. Initiation date, big change which has come in during through this Amendment Act. Earlier, initiation date had a different meaning. It was not linked to anything. Now, the this date with this revised definition is linked to the look back period, primarily. Okay, for all the buffet type of transactions. Now, here it is the oldest pending application date when the insolvency is ordered. Okay, this is important. Not the oldest application in its absolute terms, but pending as on the date of insolvency, whichever is the oldest. Now, it could be that some other application which has been made subsequent in time gets admitted and there is a pending application. So, the pending application filing date will be the initiation date. But prior to this pending application, suppose there were 20 other applications over the last few years. They don't, and if they all got settled, dismissed, whatever, gone. They don't matter. It has to be pending as on the date of insolvency. Any questions? Please, at any time. Okay.
Initiation date means earlier it was date of filing, not
Initiation
listing
date
before.
is date of filing. Yes.
Now, what is the change it is made, sir?
Now, what is the change is it is not just the date of filing of the admitted application, but it is the date of filing of the oldest pending application as on the date of admission. Big difference. Suppose you have filed an application. Okay. 1st January 2026. There is somebody else who has filed an application 1st January
Suppose
2025.
XYZ banks have filed 1, 2, 3.
I am giving the example now. Please hear. So your application, which is filed on 1st January 26, and when you filed it, there is another application which has been filed, let's say 1 year before by somebody. It doesn't matter. 1st January 20. On 31st January, your application gets admitted. 7/9, it doesn't matter. Okay. The insolvency commencement date is, let us say, 31st Jan 2026. But the
Okay, sir.
application filed on 1st Jan 25 is pending on that date. The new definition is the initiation date will be 1st Jan 2025, not the filing date of your application. Earlier, it was the admitted application. Now it is the oldest pending application.
Now, suppose my application is admitted, that has no relevance.
For the look back period. So what used to happen is that later applications would get admitted, and your look back period also started from 2 years backward from the insolvency commencement date. Now they are saying the moment there is an application filed, the corporate debtor is on notice. Okay, anything that you do from now on can be considered as a PUFE application, whether that gets admitted tomorrow or does not get admitted, irrespective of that. So it is like the interim moratorium which starts with filing. This is the reverse of that. This is that the cause of action for any PUFE application has started the moment somebody filed a IBC application.
Okay, sir.
Got it?
Okay, sir.
Yes, Ganesh.
Sir, I think it is date of registration, right? Not date of filing.
Filing.
Because after filing, there could be defects.
Yeah.
After scrutiny of defects, there's a date of registration.
I mean, as far as I remember, it is date of filing, but
because the registrar would have
No,
access.
it is not date of filing, sir. It is date of listing or first listing
That's
or
different.
giving registration number. Because why it is so? After filing,
not why. Let
nobody
us
is
go by
attending, sir.
definition. Yeah, we don't decide what is the date. What does the word say? Initiation date kahan gaya? 1 second. Date on which an application is made before the adjudicating authority has been held to be time and again the date of e-filing and nothing more. This is how it, because there are judgments on this. What is the date of application? It is the date of e-filing. Okay?
Yeah. The only thing is
this is a settled law.
Yeah. The just input is
because this is how interim moratorium section 96. This is all based on this.
Actually,
you file a defective application which is meaningless, but keep it pending.
Yeah, but that's why interim moratorium is taking advantage of that. Yes.
Yeah. So see, because of the e-filing, what is the date, which date it is. So even under the courts, other courts, the diary number used to be taken, not the registration number. Because the day you have filed, after that court might take time for its own reason. It need not be your fault. That should not put the litigant at adverse. So the general jurisprudence is date on which you have filed. Of course, if it is rejected for subsequently and not registered, naturally it has become non-est. That's different. But as long as it is pending and not rejected, then the date of e-filing will be the date.
Yeah.
Okay. Yeah. Resolution plan. Okay. Of course, expanded version, all the confusions that were there, can it be done, can it not be done? So yes, merger, so restructuring, which is not much done because mostly it is OTS in the garb of resolution plan. But yes, restructuring can be done. Very few plans have had it. Merger, amalgamation, demerger, sale of one or more assets. Now this can be part of the plan. That as part of the plan, one can propose that asset A, Y, Z, whatever, 10 assets are there, 3 I will sell it off. Obviously, it is a commercial matter, so it will be negotiated what the money that comes in will be used, how the sale will be done. And through one or more plans. Now this, of course, the idea behind is to give a statutory recognition to this project-wise insolvency, which was a judicial mandate which was being done. It did not have legislative backing. Now with this definition, it has got legislative backing. The moment you say one or more plans, fine, you are covered. Okay. All the project-wise insolvency experiments which were done, now that has now been codified. Voting share, these words are added to the members of the committee. This is because of disputes which have come. There have been sort of related parties, basically, who have said we are financial creditors, we will also vote. And there was some tussle as to it. Not really required, but added. Okay, just abundant caution, nothing great in that. Now this is about admission. Admission of an application under Section 7. So 5A, admit the application if it is satisfied that a default has occurred. Default is primary. Application is complete. No disciplinary proceeding pending against the proposed resolution. Professional. Now, coming to the explanation. It is hereby clarified. That means one, as if it was always there, retrospective fact, that if clause A is satisfied, clause A here being default has occurred, application is complete, no pending disciplinary proceeding, then application has to be admitted. No other ground shall be considered to reject an application. Now, this is basically overturning Vidarbha through a legislative amendment. Okay. Even recently, now Supreme Court a few days back did something which is contrary to this provision. Just 2-3 days back, I think people can read that, where somebody holding a decree was told that this is the company is in good, not insolvent otherwise, and you have to go somewhere else to execute your decree. You can't initiate a insolvency proceeding. Now it has to be tested against this. Okay, when there is a clear-cut legislative mandate which says nothing else except this, how can that be done? Okay, we will leave it at that stage.
But that I think, sir, they have used it for the purpose that this is not a recovery mechanism. They try to differentiate that recovery.
See, the word recovery mechanism is not used in the code.
Correct.
Right? This is a judicial creation. All that is there is section 65. Purposes other than insolvency resolution. Agreed that judicial discretion has to be there in any law. That's understood, because nothing can ever be codified completely that you don't need judges. You always will need judges. Now, the code also says that a decree is an evidence of default. So how can you say, oh, you hold a decree, you can't, but that fellow holds a decree, he is okay. Either they say that all decree holders, none of them can apply. So there is a problem. I am not getting to the merits or demerits of that case. It's a Supreme Court judgment. Till it is overturned by the Supreme Court itself, it will stand. It will be the law. And we do know, we have to recognize that all judges are humans. They all come from the same society. No one is infallible. And maybe in the circumstances of a case, in a way, while Article 142 is required to do good, it is also to prevent harm, the corollary of that. So sometimes there might be some application which is purely, collusive. But in this particular case, what happened? That about 70% of the amount being paid, the party had already deposited in court. So that actually went in favor of dismissing that application.
It's a very specific case.
Yeah, so it will not be a precedent. Yeah. Okay, explanation 2. Equally important as explanation 1. That one is if these criteria are fulfilled, no, you have to admit, you cannot reject. Second is where the record of default with an IU has been furnished, no further evidence is required. No more fishing for anything else, asking it. Once ROD is there, it's conclusive. Okay. Nothing else is to be looked at. But there is a caveat here. The existence of the debt itself could be a question. There might be a default, there might not be a valid debt. That can still be looked at. Whether it is a debt itself, okay, fulfilling the criteria of debt. The legality of it, the validity of it. Default might have been established, but the debt might be a question. Yeah.
10A,
Yes.
10A will be still checked, right? 10A,
Huh?
10A, 10A.
10A is a different
It will be
specific
checked here.
for provision for COVID, and it will always remain because that 10A says forever. Okay. The 10A provision says never can a insolvency petition be or application be made for a default which has occurred during that period. Never, which means never.
So the question is, typically what happens is record of default, you will prepare, the suspended management do not really check or bother for some reason or other. And then when the actual application is being heard, they bring in 10A. That's where 14 days actually goes for a
The
toss.
10A is a statutory binding provision that if the default might have occurred, you might have a record of default. If it falls within 10A, that is the second thing. First is at the apex, once there is ROD, no further evidence is required. 10A is an eligibility, not evidence. Evidence, ROD. Eligibility, 10A. So you have to fulfill both criteria. Okay. Any question? Too early in the morning, people. So, okay. Withdrawal of application. Lot of water has fallen. Byju's and before Byju's, after Byju's, in between Byju's, etc. Everything has happened. And ultimately, the Parliament and Parliamentary Committee and government decided enough is enough. Let us put a quietus to this once and for all, that no withdrawal can take place ever without the approval of the COC, which means COC has to be found. And what is this saying? Okay. This is looking at practicality without acknowledging it. That you as a debtor, corporate debtor or otherwise, you are aware there is a default. Nobody knows it better than you. You have got notice of it. You have had sufficient time before NCLT, usually in months, whatever the law says 14 days, but because of the court calendar itself, it will go to months. Even after starting hearing, the NCLT itself gives you a lot of time because both of you say we are in discussion, settlement talks, then you do nothing. You wait, it gets admitted, then next day you file in NCLAT. Then everything is ready to file in NCLAT. Well, both हो गया ये, okay. NCLT proceedings or anything cannot be used to buy time. The moment it's admitted, now you have to go through the rigors of this 12A, and this is how it shall be. So there's nothing wrong with it. Yes, there is still one window which is before admission. Because it is not an admitted case, it is always between, it is still a proceeding in personam. It has not become a proceeding in rem. So it is between the applicant and the NCLT, it can be withdrawn anytime, with or without a settlement. There is no such requirement. Even now, it is not there. Withdrawal has to be with the satisfaction of 90%. What are the terms of withdrawal is not mentioned in the code, and that is deliberate.
So this is the first EOA that you issue, sir. Expression of interest.
What is it?
For the 12A.
Invitation for submission of a resolution plan is RFRP, not EOI, not Form G. Please, I think a lot of people get confused. Good thing you pointed it out. This is RFRP. This is not EOI.
Okay.
EOI is only inviting prospective applicants, not submission of a plan. First stage, chutney ke liye, eligibility criteria, all that. Invitation for submission of a plan, when you read the regulations, you will find it basically is the RFRP. The term RFRP is not used in the code. It has practice, but that's what it means. You invite to submit a plan only those who are eligible under your conditions. So, stage 2. Because Form Gs can fail. You may not get any EOI. First round, second round, it happens. Does it mean you can't withdraw? Yes, you can. But once you ask for resolution plan, it is assumed now there are parties with interest, no more time for withdrawal. Okay, section 14, yeah.
Once the resolution plan comes,
Mr. Jha, you want to say something? Sanjay Kumar Jha? No.
Before admission also we can withdraw, no, sir, by filing an IA or compromise.
No. Before admission, just now I said, please listen carefully. The insolvency application, whether under 7, 9 or 10, okay, 10 will not come here, 7 and 9, is a proceeding in personam between two parties till the date of admission. Once it is admitted, it becomes a proceeding in rem, which means between the corporate debtor and everybody else. Okay? So as long as the admission has not taken place, it is only between the applicant and the NCLT. They can withdraw whenever they want with the leave of the court. Okay? The court might say you have filed frivolous application, will fine you, all that is fine. Conditions for withdrawal, that is under normal court procedure. Once admitted, 12A applies. 12A does not apply before admission. Okay?
my question is once.
हाँ जी, थोड़ा जोर से बोलिए, बहुत soft voice है.
My question is
हाँ.
कि when the resolution plan we received, then we cannot withdraw.
No. When you ask for a resolution plan, जब RFRP issue करते हैं पहली बार, उसके बाद नहीं, no withdraw. Plan आए या ना आए, whether plan comes or does not come, the moment you have issued an RFRP to whoever are the PRAs, suppose आपके 10 EOI आए, finally 6 are eligible, okay? Then to those 6 you will issue no RFRP, request for resolution plan. तो जिस दिन आपने पहला RFRP इश्यू किया तो 12A की घड़ी बंद होगी. Okay, right. Section 14 moratorium. What is added here is that about surety. This is a clarificatory amendment. Basically, that's why the word clarified is used. That even a surety cannot have any proceeding against the corporate debtor. Okay. So any surety who has through subrogation achieved a right to make a claim against the city will have to just file a claim. No other action can be initiated. Section 10 change in terms of appointment of the IRP. Now the corporate debtor, who is the applicant under Section 10, has lost the right to propose any IRP or RP, who becomes the RP. It shall be the board. This is, of course, to keep the independence that is envisaged under IBC. that the IRP shall always be a person independent from the corporate debtor primarily. Okay, collation of claims in such manner, because this was missing earlier, the word collation has gone through so many litigation as to what it means and what it does not mean. At one time it went to the extreme that collation is just adding it up. 10 claims total, put the figure, what is the claim, add up, and that is the total of it. Then of course we found a creative way of not rejecting a claim by saying it is under verification, which was primarily saying rejected in most cases. So now the power to make regulations as to how this will be done has been codified. Okay. So in such manner it may be specified. That means regulation will tell how this act of collation will apply. The word collation has not been changed.
One thing I want to ask.
Now, explanation. Again,
one
one second. Explanation, same thing, clarificatory. The IRP, while collating the claim, shall verify them. Now, we were doing it, but it was not provided as such in the code. And as I said, so there were some litigants who said you can't verify. Once whatever I give, you just have to collect. So now it says the legislative backing that you shall verify them. Shall, not, there's no discretion here. That the IRP has to verify them. And if required, now this is the contentious part, determine the value of such verified claim. Just one second. Now, determining the value of a claim, there is a relatively simple situation where it could be a debt in foreign currency. Naturally, it has to be translated into Indian rupees, how it shall be done. So that is one determination of value. Second, it could be a bit uncertain. Some part may be certain, some part may be uncertain. Maybe interest clauses are there to check that. Third is a lot of uncertainty where, and this is situational, okay, that IRP doesn't know what is the real value of the claim. Okay, there's something which party has put in. They have interpreted, say, for example, claims arising from certain what do you call that, penal or damage type of clauses in a contract. How do you arrive at that? So this is the problem that IRPs will face. This will be a huge implementation problem. But the power has been now given to the IRP that you can determine the value of the claim, which means you don't necessarily only accept what the claimant gives, which is what was the position as understood prior. But now it is clarified that no, it always was that the IRP had the power to verify the claim or even determine the value. Yes, Sanjay ji, you wanted to ask first. संजय कुमार झा, बड़ा आपको
आवाज आ रही है? मेरी आवाज आ रही है?
हाँ, अभी आ रही है।
हाँ सर, मेरे तरफ से एक क्वेश्चन है कि जैसे एक कंपनी ने अप्लाई किया एज ए फाइनेंशियल क्रेडिटर एनसीएलटी में फॉर्म सेक्शन 7 के एप्लीकेशन के लिए, उसकी फाइनेंशियल क्रेडिटर की स्टेटस ख़त्म हो गई, एज ए सिक्योरिटी इंटरेस्ट उनको फाइंड आउट किया गया कि स्पेकुलेटिव इन्वेस्टर के रूप में उनको आइडेंटिफाई किया और एनसीएलटी ने उसके केस को एडमिट नहीं किया, एनक्लेट में भी नहीं किया। अब वो क्लेम लेकर के सेक्शन 10 में हमारे पास आए हैं कि हमें फाइनेंशियल क्रेडिटर कंसीडर किया जाए। क्या हम फाइनेंशियल क्रेडिटर कंसीडर कर सकते हैं इनको?
See, where a creditor's category of claim has itself been decided by NCLT at the time of admission. Hello, please. Rajiv Bhatnagar, please mute your mic. Can somebody do that, please?
Harish, you need to do that.
Yes, I am doing, sir.
Where is the noise coming from? Sanjay Jha. Okay. Yeah. So, where a court or tribunal has determined that a particular claim is not a financial debt, then IRP or RP cannot sit in jurisdiction over such determination. You have to say no, it is already decided by a court or tribunal that yours is not a financial debt. I cannot admit it as financial debt. Ho gaya, khatam. Okay. Now the question will be, is it still some form of claim? Because the definition of claim under IBC is very vast. It includes disputed claims, unmatured claims, claims to be determined by a court, sab kuch. So there will, if the money has come into the company, other than as equity, then it is a claim and has to be admitted, whatever it be the category. There will be the category called others. It may still be an unverified one. It may be admitted if the value is indeterminate or cannot be determined, admit it at 1 rupee, just to say that there is a claim, but I don't know its value. So admit to karna padega, but not as a financial debt because that has already been decided कि it is not. समझ में आया? जहाँ साहब?
सर सर आगे
Clear? Okay.
लेकिन someone saying कि if the उसके बाद फिर उन्होंने क्या किया कि एग्रीमेंट एक अलग से बना लिया, अपने लोन को उसने कन्वर्ट करा लिया एज ए फाइनेंशियल, उसने कॉर्पोरेट
बाद में बना लिया मतलब
जब जैसे
बाद में क्या होता है?
सेक्शन 7 की जब उसकी रिजेक्शन हो गई,
उनका सेक्शन 7 रिजेक्ट होने के बाद उन्होंने बनाया मतलब
अब वो कह रहे हैं कि हमें फाइनेंशियल
नहीं, आप थोड़ा माइक के पास आइए, योर वॉइस इज टू लो।
उसने बनाया बाद में, जबकि उसकी रिजेक्ट हो गई सेक्शन 7 की एप्लीकेशन।
ओके,
ये फाइनेंशियल क्रेडिटर नहीं है।
हाँ,
के बाद उसने आपस में एक एग्रीमेंट किया और उसे शो किया कि हम अपने
मतलब पहले जो
लोन में
इन्वेस्टमेंट
कन्वर्ट
के
करते
तौर
हैं।
पे आया था उसको डेट में कन्वर्ट किया।
हाँ किया, उसके बाद में
ओके,
10 की
तब तक कोई एडमिशन हुई नहीं थी, करेक्ट?
हाँ जी जी जी।
बाद में क्या सेक्शन 10 एडमिट हुआ या दूसरा कोई
सेक्शन 10 का एप्लीकेशन एडमिट हुआ बाय द कॉर्पोरेट डेटर।
एक मिनट अगर आज के दिन पे सब्सिक्वेंटली वो सेक्शन 10 एडमिशन है, ओके, तो सेक्शन 10 में कैटेगरी ऑफ डेट तो कॉर्पोरेट डेटर ही बताता है कि कौन सा क्या है। उसके बैलेंस शीट में अगर वो फाइनेंशियल डेट करके दिख रहा है ऑन द डेट ऑफ एडमिशन, तो नेचुरली देखिए कैरेक्टर ऑफ डेट कैन चेंज। ये कोई कानून में प्रोहिबिटेड नहीं है। ऑपरेशनल डेट कैन बिकम फाइनेंशियल डेट, डजंट इज नॉट प्रोहिबिटेड। अली क्या होता है अंडर आईबीसी, इफ इट इज डन टू सर्कमवेंट द लॉ, मतलब इन अ फर्जी मैनर, नॉट ओनली टू फॉर द गेटिंग इट इंसॉल्वेंट और गेटिंग अ क्लेम, तब जाके वो रिजेक्ट होता है। अदरवाइज नॉर्मल कोर्स में आपने किसी को इन्वेस्टमेंट करके पैसे दिए, ओके, यू मेक शेयर एप्लीकेशन मनी, लेट्स बी वेरी क्लियर कि टू इन्वेस्ट इन शेयर्स, the shares never get allotted for whatever reason, then it is converted by an agreement into debt.
Okay.
Nothing illegal about it.
Okay.
Provided at that time there is ये insolvency का भौर ऊपर नहीं मंडरा रहा है तो, but when insolvency is likely to happen or has actually happened but not yet admitted and तब जाके करते हैं, so then it hits other provisions of insolvency. This is like to bypass that, okay? So mens rea बोलते हैं जिसको, तो it sort of becomes a deliberate malicious act.
Okay.
In general, conversion of one type of debt to another is not barred in law. Convertible debenture होते हैं ना?
Okay.
Debenture होते ही equity. So it can be by itself. But जब insolvency immediately हुई है, तो it is suspicious. So in such cases of doubt, it's as an IRP, it is better to not to admit and let NCLT determine its real status. Because अपने पास वो ना capability है ना power है.
Okay.
Okay.
Thank you, sir.
Okay. Now, who are the persons required to extend cooperation? This is expanded again, the definition. So it includes the city, personnel of the city. Personnel of the city usually means the employees of the city. Okay. Or its promoter. Matlab promoter is also party to. Now, a promoter may not hold any direct office in the corporate debtor. ये ध्यान में रखें, every director is not a promoter and every promoter is not a director. There might be promoters who hold the, who are promoters, who have the power, but they don't hold any office in the particular company. Okay. So promoters, but are covered under the 19.2. Or associated with the management of the city. Now, associated is a very vast definition. So it can cover employees of a group company who have some sort of management, association with this management. Those who are engaged in a contract for service with the city. Now, this, of course, it does not say goods. So suppliers of goods are not covered, but all those who have a contract for service. So it can cover your auditors, it can cover your financial consultant, management consultant, company secretaries providing service, any other person who provides any type of service can be covered. So all such people you can ask to give you assistance and cooperation. Yeah, Section 21, Committee of Creditors, now power expanded to oversee the liquidation process also, which means there is no separate formation, no requirement of waiting for claims. In fact, that all those clauses, sections have also been deleted. And the COC as it stands, which means all unrelated financial creditors, if there are FCs, otherwise OCs under whatever regulation. All of them. Now, this COC will be the one to supervise the liquidation process also. Now, supervise the conduct. So, there is a change in the shift in terms of the power. The SCC was originally considered only as an advisory body. Then the powers of the SCC got expanded through regulations. But now, again, same thing, the legislative sanction that the COC will continue to have and basically will exercise the same powers which it had as a during CIRP. Now, there is a proviso that the board may specify any other class or classes of creditors who may attend the meeting, that is observer status, without having a right to vote. No right to vote does not mean that they don't have a right to participate. They can. That is the reason they are there. Okay, they have a voice, but they don't have a vote. Confirmation of IRP as RP. Okay. Now, wherever an IRP is confirmed as RP, the existing position was that the adjudicating authority had to be intimated and it used to be obviously by way of IA, because every communication, the only way that an IP can deal with the A is by way of an IA because of a order of the NCLT president. And IA means obviously registration, listing, hearing, passing of an order. Now, the Parliament decided to delete that provision because the person has already been appointed. Is only being confirmed for continuing for the phase 2. Because that's the peculiar nature of our IBC, that the first appointment is considered as interim. So, if the COC confirms that the same person shall continue, because they are the ones with that power, what is the need to, go through the process of informing NCLT and going through all that IA process? So it was deleted in this section, but as we saw otherwise on the other day, it has got reintroduced back in the regulation that it shall be intimated. Practical difficulties might be there, but we will not get into that. But the section itself does not require intimation to A when it is a confirmation of IRP as on. However, if there is a change, a different IP is to be appointed, then definitely it has to go to NCLT and NCLT has to do the appointment. Okay. Transfer of assets of the guarantor, new provision. This is a concept called pooling of security interest, which was there to some extent during the corporate debt restructuring days, CDR days. This is where a particular creditor, or maybe more than one, have an interest, security interest on an asset which does not belong to the corporate debtor, but belongs to a corporate guarantor or a personal guarantor of the CD. And if such creditor or creditors have enforced their security interest on it and taken possession of the same, then during the insolvency resolution of the corporate debtor, which is now ongoing, they can bring that asset and offer it into the pool. Now, first they have to agree, whoever is that. Then the COC of this particular CD also has to agree that they want to take that, because nothing comes free, right? So the one bringing in that such an asset would obviously have certain terms associated with it. They will assign a value to that. They will expect that value to be recognized during the resolution of that CD. So the COC of that corporate debtor has to agree. And the creditor can then pull such a asset into the resolution part. Now, does such an asset become the asset of the CD just because the creditor brought in? The answer is no. In law, this still remains as a separate asset. And how it will be transferred to the resolution applicant or the corporate debtor later on will have to be worked out depending on the situation in each case. Now, the amount received pursuant to the transfer of such. Sorry. Now, the subsection 3 is interesting. The amount received pursuant to the transfer of the asset. That means that the plan should specifically provide how much amount it is giving for this asset. It has to be an identified amount. Okay. So that amount shall be adjusted towards the dues of the guarantor, naturally. Okay. Because his asset has been acquired. It has now got effectively liquidated. So it has been realized, and that amount shall be set off against the amount that the guarantor owes, whether it's a PG or a corporate guarantor. Okay. Yeah. Any questions?
Sir, we have till 9 o'clock session. I think 1.5 hours non-stop talking is not easy. Okay.
Yeah, I'm already feeling.
So yeah, I know. So 9 o'clock we'll be stopping, sir. It can be a
But amazing, the kind of in-depth work you do, sir. Amazing.
exactly. So I think it's a great start for the sessions that we initiated.
Unbelievable. 7:30, I was rubbing my eyes, opened up. I saw 20 people. I thought that there'll be nobody on.
When it is
27, sir.
lecture, everyone is there generally.
Good start.
Sir,
Yeah.
you may want to stop. So what happens, sir? These coming sessions can be longer. So we generally stop by 9 and then leave it to a general Q&A so that it relieves the speaker also the burden of speaking.
No, yeah, that's why I said, okay, I would want questions to be here, but still talking is there. I will just cover this last section now, section 30.
28A, have you think you're over, sir? 28A, you want to say something else?
हाँ नहीं 28A तो अभी cover किया.
Is over. I think you want
Yeah,
to
yeah,
say something
28A
else?
is over.
Okay.
Okay, from my side is over. Questions, of course, welcome.
Yeah, questions, because this is a relatively a new section for many to really think through. I don't know whether people have thought through.
No,
Any
it will be difficult to, but broadly, I will say, okay, in terms of implementation, if firstly there has to be such an asset available, which is needed by the RA for the resolution. If it is just a random asset which has nothing to do with it, naturally, there is absolutely no point in including it here. So typically, this is an example. I mean, the most common example will be the land which is owned by the promoter or some other company, where the factory or the real estate on it is in the city. So naturally, you can't have one without the other. It is an essential requirement. In such cases, you need to ask for it.
So
the power is there in a way. I mean, this is now come under IBC. The power was there under SARFAESI with the creditor if the RA wanted to take advantage of that. Hardly happened. It cannot. There is been some misconception, I would say, that just because it is there and it is in, it can't be separated. It is an essential requirement. The plan itself no longer is feasible, or without that. So a judicial fiat can actually make it happen. Now that is a misunderstanding of law. There is no such provision given under IBC specifically. Because the promoter is unwilling, let us say, or the owner of the land, let's not call promoter, whoever. It is like a merchant of Venice, you take the blood, take the flesh, but not the blood. So that has now been covered, because now this is also a warning in a way to creditors that if you are lending to an asset where the underlying land is not belonging to the CD, make sure you have a mortgage on it.
Yeah.
So preventive, you make sure that you do it. कल को फिर रोना नहीं, अरे what can I do? Then you cry. Okay, no sympathies, no tears shall be shed.
So the complications in 28A, one were to say, here it says largely the creditor, basically of the basically personal guarantor or corporate guarantor. He's talking about them, and he's saying that they transfer this asset to the corporate debtor.
They don't transfer.
No,
I mean, the word transfer is used, but actually they transfer it to the acquirer finally. They pool it.
Yeah, correct.
There's no actual transfer as understood taking place, but it is brought in, made available, pooled, but transfer happens through any other document which might be required.
So, assuming the question that, I will leave others to ask before that Mr. Jayant has raised their hand, so I can wait for
So we'll ask him first, okay? Let's finish with him first. Mr. Jain, Pimpalgaonkar, go ahead.
Yeah. Sir, my question is, now in this under section 28A, that means the financial creditor first need to take the possession of asset before it comes into the SRA, before hand over to SRA.
Absolutely, absolutely. They have to, just by saying I have a mortgage right, then you can't put the RA into trouble ki maine to de diya, aap le lo abhi. Because it might be an encroached land. It might, the holder of the land might not want to give it. Just as an example. Or the mortgage itself might have a defect.
Yeah.
Who knows? Okay. So,
Yeah.
said you have to ensure that there is clear title and possession before you transfer it. You can't bring in a asset into this which has got question marks attached to it.
Okay. Thank you, sir.
That is
Thank
to
you.
protect the RA, basically.
Yeah. Okay.
Sir, okay, continuing the same thing.
Ah.
Under the IBC, because if you do a resolution plan, 32A comes into the picture. Okay. After the successful approval of the resolution plan. But this particular land parcel that does not belong to the corporate debtor, invariably, if there are any dues which are attached to the earth, essentially, because underlying land is there, or any such, whether it's electricity dues, whatever that comes in, and therefore the land arrears are there, RA is not getting any such benefit. All that he has to satisfy as regards to that land.
Yes. Buyer beware.
Buyer beware, right?
Every tempter has to be there and it must be there.
Must be there. No.
The IBC is not a clean pass to do whatever you feel like. No.
Correct. So,
okay. Section 30, the payment to dissenting FC, that clause has been modified. Now it is very clear. Earlier, even the printing was a problem. There was one clause hanging somewhere and then the part was going under and nobody could realize whether it meant part of the previous subsection or the next one. So now it is very clear it is the lower of the two. That is either the liquidation value or the amount proposed in the resolution plan. Whichever is lower, the dissenting FC will be paid. Now this is in contrast to the OC and that is deliberate. It is not an oversight. OCs are not part of decision making, hence they are protected to higher of the two. FCs are part of the decision making. They know what they are going to get now with this clarification. Even after that, if they dissent, it is up to them. They have decided to take lower. Okay. Simple this thing, but important.
Sir, how does it solve Amit Metallic's problem? I'm just questioning that. One of the reasons is...
And Amit Metallics is not here.
No, yes, sir. I'll come back to...
Amit Metallics is elsewhere. It is arising from a different clause. We will come to that. That is not covered under 30 directly. Okay.
Yes.
Yeah. We will come to it because that's basically 53. It's not here. It's 53. The explanations added under 53 are the one which cover Amit Metallics.
I'll ask, sir. Okay, sir. I'll wait.
Okay. Supervising committee, monitoring committee, whatever name we called it, over a period of time, it started as a practice. It became part of the regulation. Now it is moved upward to the act itself. So it has got a complete legislative sanction at the highest level possible. And so a monitoring committee shall now be having, it will be a statutory body. It will, like the COC. Okay. Now, this is no longer a option. Provides for, that means the plan has to provide for such a committee. It is no longer may. It has to be done. Even if it is only for 30 days, 60 days, 90 days. Even in a plan which involves only a single upfront payment, till that whatever has happened, till the certificate is given, the plan has been implemented, it will be there. Okay. Regulations will cover the detailing of that. Next important change. Now this is going to be extremely useful, at the same time can be the source of multiple litigation. That the COC has to now give reasons for approval. It doesn't have to still does not have to give reason for rejection. Okay, you can reject anything without assigning any reason whatsoever. But now it has to give reasons for approval. Q1, when it says reason for approval, which means preferring one or the other, if there is more than one. But if there is only one, also justifying why they have done it, which I would expect would include that they will have to say it is higher than the liquidation value, etc., etc. Some commercial reasoning behind it to some extent. Now, whatever reason they give, if there is more than one plan, it could give cause of action for the others who have lost out on the race to litigate on these grounds. Could. I'm not saying it will, but it could. Okay, so today we stop here. We are 8:59, just 1 minute before 9. So we are stopping at section 30, I think. 30, submission of resolution plan. And I will stop the sharing. Yeah. Let's have few minutes open house. No problem. Asmin.
So I'm taking indulgence on again Amit Metallics with your permission, sir, because it's open house
We will
now.
cover Amit Metallics separately.
On the 30 to be changed, there's an impact as per I'm assuming
No,
that
because you see, the connection is with 53.
we do
Okay.
at 53 or something.
So when we do 53, this will
Fair
be
point.
covered.
Fair point.
And that time I will also cover what does it mean by saying, to the extent possible, etc.
Sure.
Such words are
Fair
used.
point. Fair points.
It will be clearer because we need to cover that.
Agreed, sir. Agreed.
Yes.
Uh,
Some things are in chat. Let me just check if there is any question. What is this? Filing period? No. Filing period, I think that is now judicially decided. That date of filing is the date. So regulation 31A is deleted or SCC would still continue? No. There is no SCC. There will be only COC. Yeah, well, there are only two questions. Yes, somebody wanted to ask. Harish, you wanted?
Sir, now these regulations, which is implementation date, not yet notified.
Sorry?
The implementation date of this amendments is still has to come.
Not yet notified. The act has received assent of the president, but the date on which it will come into force is yet to be notified. It will happen. I would presume that it won't happen unlikely before 28 May, I think.
But did
Because
they
the last date for giving suggestions for regulation. And once IBBI probably gives a signal to the government that yes, we are ready to notify the regulation, then they will probably notify the act.
So one more question, sir.
Either way, we can expect around first week of May. My expectation is around first week. Both will get notified.
Up to 28, so they have called for suggestions. So it may
28
take-
दिया है, so first week of May, because they are not going to go through all the suggestions too much anyway.
Harish sir,
One-
can you stop
so
the
one more
recording
question.
now? Session is over. It's an open house session.